boldip.com.
Hi there, my name is J.D. Hoovener, and I'm the managing partner here at Bold IP Law Firm. And I want to make sure we do a quick introduction about the law firm in case this is your first time viewing our Bold Bits station. Bold Bits is our opportunity to share with you, the inventor or business owner or entrepreneur, just a little bit about patent law and what it's all about. And we decide each month to send out a video about the law and about what you need to know about how to move forward, just to help you be a little bit more knowledgeable about the process that seems to be so obscure and is unfortunately really not in the mainstream. Bold Intellectual Property Law is a boutique patent law firm, and we are agile, business-minded patent attorneys. And don't miss it, business-minded, meaning we help inventors and business owners think about how they're going to make a return on their investment as soon as we start writing the patent application. So we do pride ourselves on writing those patent applications with the business plans that should go along with them, so they know all this work and hard work and money up front is going to be worth it in the end. I also want to introduce one of our publications last year, a really easy guide for inventors to get to know. It's called Bold Ideas, The Inventor's Guide to Patents. It's a really quick read, 120 pages or so, and it gives you all the good outlines, all the information I think you should know before you sit down with the patent attorney. So today's version of Bold Bits is going to give you a fairly brief rundown of the 9 things that are needed to submit with a non-provisional patent application. And so we've been on discussing some differences between the provisional and a non-provisional patent application. So I'll be very brief on what the difference is there. A provisional patent application is a less formal, therefore usually less expensive because it takes less work, application. And in it really is the heart is the specification, which is the written description of what the invention is in words, along with any drawings as needed. That's it. That's all. That's what a provisional is. Its whole purpose is to preserve a date in time so that the non-provisional, the full formal application that must be submitted 1 year after or sooner, then the provisional can make reference back to that earlier date in time when the provisional was filed. So I want to talk today about that non-provisional filing, that formal, all-encompassing application that will make reference back to the provisional, but must have 9 things in that application before it's submitted. So first and foremost, the least exciting, let's say, is the fee transmittal form. This form is what the Patent Office will take forward and identify, okay, what are all the fees that need to be paid here in order for this to get submitted to an examiner? And yes, indeed, there are a number of different fees. So the examination fee, okay? The examiner must be paid for doing that examination. That's simply reading the application, understanding its claims, and any drawings. Okay, there's also a search fee. The examiner does their own search, and they're quite good at it. But there's a separate fee to be paid for that. Now, there's also what's called an application fee. So that's just the administration of entering in the application, giving it the electronic format and accessibility options for publication later. Now, there are certain fees that vary, and that depends on entity size. And therefore, number 2 is the entity size form. The applicant must identify which of 3 major categories they fall into. And if they don't decide that they can't, if they don't submit the form at all, the default is a regularly sized entity. Just know that what comes along with that is a larger bill, most likely. And so the fees are at the full bill amount. Now there's ways to get the fee reduced. And that's if you file what's called under small entity. And a small entity is really not what you're thinking. It can be actually a fairly good sized company. Many of our clients fit into this category, where there are fewer than 500 employees, and there's no obligation to assign the invention to a company that's greater than 500 employees. So you can think of a number of different companies, maybe some that you work for or work as a contractor to, that would fit into the small entity description. And for that, the Patent Office wants to encourage those smaller companies to be innovators. And so they actually reduce the fees almost in half to be what's called a small entity. Now, the United States Patent and Trademark Office has gone even further, and they've offered what's called micro-entity charging. And so micro-entity fees are, again, almost half of what the small entity charge fees are. Now, to qualify as a microentity, you have to have certain income thresholds. So you as an individual inventor cannot be making more than 3 times the median income. Now, that's a published, documented figure that, of course, does change every year. So that's a big threshold to get through. Not many of our clients, but some do, are able to file as a microentity, and there should be a separate form for that. And so that's number 3, what's called a microentity form. If there is an opportunity to attempt to file for that, we should for sure include that, because the reduced fees are going to help quite a bit to free up that time to do some business planning, or use those fees, the resources rather, to help perhaps do a prototype of the invention and help move it forward through testing. The 4th piece of paper, the document that must move forward, is the specification. And don't miss this, folks. This is really the heart of the patent. This is what makes up the written description, the detailed explanation of the figures, and last but not least is the claims. Okay, so those big things, and there are some other formalities including the abstract, but basically everything that's in written language is included in the specification. So this is huge, and we can have a separate discussion about the specification. So that's the 4th document. The 5th is the drawings. Okay, it's a separate field, and the drawings surely relate to what's been discussed in the specification and should bring to light all those different features, structure, and even components in 3 dimensions that are really unable to be articulated in words. And so that's why drawings are brought about. That is the 5th major document. And just know that there can be a number of different drawing sheets. You're not limited to 1 page. In fact, in many cases, that would be sort of a disservice to the invention. And in many cases, 3, 4, 5 sheets are included, and many more as needed. The 6th major form that must be submitted along with a non-provisional patent application are the claims. And I want to bring up claims separately from the specification because they do have that much more of an importance. The claims are what define the patent. This is the bread and butter, the heart of the patent. It's what really a court would look at when they say, well, what is this patent? Even though the general public, and even I'm guilty of this, will look at an image, the drawing itself, of what was published for that application, when really to understand what the invention is claiming, you've got to read the claims. It's kind of a no-brainer, but one of those things that some people forget. And it could be that invention does not really cover the entirety of what's shown in the drawing, but in fact just a very small component or improvement thereof. So don't miss that. That's claims, and that's the 6th major piece of information that must be sent to the Patent Office when you send an application in. We're getting close, folks. The 7th document must be submitted. It's called an application data sheet, an ADS for short. And this is basically what you're thinking. It contains all the inventor's information, address, phone number. It also puts down the attorney's information, the law firm, and any other assignment information. So let's say you work for a company and they have a provision where you as an employee are obligated to assign your invention to the company. The company's name will be listed there as an assignee. That's the 7th piece. The 8th piece is the information disclosure sheet. This is a big one. As part of the duties of the inventor and of the attorney upon filing is to come forward with any information we have about the prior art that we've found. And so in doing a professional search, of course, we've got a number of different what's called prior art references and patent documents. All of those must be rolled up and presented to the examiner upon filing. So we've got to come clean. Anything we found that's even close to ours that we found in preparing the application needs to be identified in what's called the IDS, the information data sheet. And so there's 2 different subparts. One is the patent documents. One is the non-patent documents. There's separate subsheets for each of those, but I package it all together for you as the 8th. The last but not least, the 9th document is the inventor's oath. The inventor's oath is obviously very important. This is what the inventor does. This is they sign and say, yes, I am the inventor of this invention, and it's my declaration that I did not derive this from anyone else. This came from my own thoughts, minds, and creations. And so that's the last document that must be submitted and signed by the inventor or their agent before they can move forward and submit it to the USPTO. Thank you again for tuning in for this version of Bold Bits. It's been my pleasure, and I hope you have a wonderful day and enjoy our reading of this on social media. And go big, go bold.
Go big, go bold at boldip.com.